Good afternoon, everyone. Greetings from ADR and a hearty welcome to this webinar. We are privileged to have a panel of eminent and distinguished personalities today to express their views on the subject for the viewers. I think for the viewers, a little bit of introduction regarding the panelists is warranted. So I'll quickly go over a brief bio of each of the eminent panelists. Shri S.S. Ray is a Rajya Sabha member from the TMC. He was elected for the second time in 2017. He is a MA LLB and started his political career in 1968. He was the Vice President of the Calcutta High Court Bar Association from 2009 to 11. He has written 4 books, and as a Rajya Sabha MP, he is and has served on various parliamentary committees. The next is Honorable Justice Madan Bhimarao Lokur. He is alumni of St. Stephen's, Delhi, and did his LLB from the Law Faculty of Delhi University. From 1977 onwards, he has practiced in the High Court and Supreme Court. He was appointed Delhi High Court judge in 1999 and served as the Chief Justice of Guwahati and Andhra Pradesh High Courts before his appointment as a judge in the Supreme Court in 2012, from where he retired in December 2018. Welcome, sir. Shri O.P. Rawat, I think he hasn't joined. He may join another 10-15 minutes. He is alumni of the Banaras Hindu University, with MSc in physics, and did his MSc in social development planning from UK. He retired from the IAS in December 2013 and was appointed as the election commissioner in the Election Commission of India in August 2015, and later was appointed as the chief election commissioner and he performed that duty from January to December 2018 for 1 year. Professor Sastry, he is the founder, member, trustee, and chairman of ADR. He has done his BTech from IIT Delhi, MBA from IIM Ahmedabad, and his PhD from MIT University in USA. He has taught at IIM Ahmedabad and universities in Japan, Hong Kong, and USA, and is currently teaching in IIM Bangalore. And he is also a recipient of national awards for research and teaching. Welcome, Professor Sastry. We also have Mr. Alok Prasanna. He is the co-founder and lead of Vidhi, Karnataka. He did his LLB from Nalsar in 2008 and BCL from Oxford University in 2009. His area of research includes judicial reforms, constitutional law, urban and law technology. He also writes columns in various magazines and web portals. And he has also practiced law in the Supreme Court and Delhi High Court. Now, coming to the context of the discussion today, for the benefit of the viewers, I'll show a few slides because I have shared a background paper with the panelists, so they would be aware of the reason as to why we are having this discussion today. Basically, it is upon the implementation of the Supreme Court's directions, especially the last judgment, as also various other Supreme Court judgments. They have asked the political parties to share details of the candidates with criminal cases, and the last one in which they have asked them as to why they are giving tickets to people with criminal cases. So I wish to highlight that the implementation lacunae by the political parties in the Supreme Court judgment on the issue of decriminalization of politics and the guidelines which have been issued by the Election Commission of India based on the judgment, when the ADR analyzed, we found that there are a large number of shortcomings, and these details have been shared with you all, with the panelists in the background paper. However, I would urge the panelists to give concrete suggestions as to how the implementation can be enforced, and who is to monitor the ECI, which was charged with the responsibility of overseeing this, and what would be the suggested action for the non-compliance of these instructions of the, or rather the judgment of the Supreme Court by the political parties. So before I hand you over to the panelists, I would like to share a few slides for the benefit of the viewers. Anas, can you please move to the next slide? So before I explain this one, I just want to highlight what is the current status now. In the Lok Sabha, we have 43% MPs with criminal cases, and 29% of the MPs have serious criminal cases. In the Rajya Sabha, we have 24% MPs with criminal cases and 12% have serious criminal cases. Out of these, 11 MPs have murder charges, 33 have attempt to murder charges, 8 MPs have kidnapping charges, 13 MPs have robbery charges. 18 MPs and 58 MLAs have cases of crime against women. 3 MPs and 6 MLAs have cases of rape against themselves. So what we are seeing, the trend is that every election, there is a 5 to 7% increase in the number of candidates who have criminal cases and who are given tickets by the political parties to contest elections. And the way things are going, it has already reached 70 to 75% MLAs in certain states. So the day is not far off when we'll hit the century. And that will be a extremely shameful day for the Indian democracy. This is what we feel. So now coming to this slide, this is for the viewers to see that the guidelines which were issued by the Election Commission based on the Supreme Court directions. So the ones on the left, the 7 points, are for the political parties. So basically, they have to publish reasons as to why they are giving tickets to the candidates with criminal cases, and what are the reasons for not finding people who do not have criminal cases. And they have specifically mentioned that Supreme Court in its judgment had said that winnability is not the reason. You cannot say that this guy is the best candidate to win the election, that is why we are giving tickets. So they are supposed to publicize this, they are supposed to submit these details on their website, they are supposed to publish it in the newspapers, and so forth. So similarly, on the right hand side also, for the candidates, these instructions have been given. Okay, next slide please. Now this I want to show you, this is as per the guidelines issued by the Election Commission. 2 formats have to be filled. One is C2 on the left, and on the right is C7 format. So the C2 format is to be published in the newspapers and TVs from the day following the last date for withdrawal of candidature and up to 2 days before the date of the polls. In this, basically is to give his background details, name, constituencies, pending criminal cases, and details of the conviction in various criminal cases. On the right hand side is the format C7. This is the information which, regarding the criminal cases, the political parties have to be as to why they have selected these candidates. So if you see the name of the offenses, case number, name of the court, all that is in the part 1. In the second, the print is a bit small, but I am just reading it out for you, that the reasons for selection of the candidate have to be given. And the third para, the last, bottom, is reasons as to why other individuals without criminal antecedents could not be selected as candidates. Okay, next slide please. Yeah, so what I've done is basically all these 5-6 states which went to poll recently, the 4 states and the Union Territory recently, and last year Bihar. So this Supreme Court judgment came into effect for the first time in the Bihar elections. So we have been tracking as to what the political parties are submitting on their websites, and we find various lacunas. Like for example, this I have taken West Bengal. So if you see, the reasons furnished are very, they're not convincing at all. And I'll show you some more subsequently also. What I want to highlight here is that out of the 435 candidates with criminal cases, only 72% candidates' details have been furnished. And for serious criminal cases candidates, 89% of the candidates' details have been furnished. So all the candidates' details are not available. I may like to add here that our analysis and research is based on the websites of the political parties. Now, there are a number of small political parties which do not have websites. There are independent candidates who I assume would have published their thing in the print media, but we have no means to access those. And these details are not available on the Election Commission website also. This has all been found out by our research on the various political parties' websites. Okay, next please. Now this is again background. What I want to highlight here is what I have done is from each state I have taken the two candidates, the two topmost candidates with maximum numbers of criminal cases. Now in this case you see these two. 53 cases Bharati Ghosh and 50 cases Barun Parnaik. Just see the reasons which have been given. Another thing I want to highlight here is that the reasons for selection of candidate with criminal background and the reason as to why other individuals without criminal antecedents could not be selected, by and large, the parties have written the same thing in both the places, which doesn't make sense. Because in C7 you have to specify why you couldn't find other people of without criminal antecedents. There are various other discrepancies also which have been shown in the yellow box on the right. Okay, next please. Similarly for Assam. Now if you see this gentleman Akhil Gogoi, he is an independent. He won incidentally. He's got the highest number of cases, 52. And he has not published his C7. I mean, we don't know because there's no website. He's an independent guy. Whether he has published in the newspaper and all, we have no means of finding out. For Puducherry, similarly, the main political parties in Puducherry have also not published the format C7, as you can see in the bottom. So these are the two who have got the highest number of candidates, criminal cases in Puducherry. Next, please. Kerala. This is interesting. Kindly compare the remarks. They are identical. Copy paste or cut and paste. See Tamil Nadu. Format C7 not published by the political parties. Next, please. This is very interesting. What I want to highlight is they have made no effort at all. Indian National Congress in Tamil Nadu, they have given the same reason for all the 26 candidates. You can check it out. I have taken serial 1, serial 2, serial 6, serial 9, serial 21 and serial 22 or something. Exactly same reasons have been cut and paste for all. So that shows the seriousness with which the Supreme Court judgment is being taken and the Election Commission's guidelines on the subject are being taken. Next, please. So many other discrepancies are there. I have highlighted these in these box. You can go over them. But like, for example, Stalin, he is the chief minister now. In C2, there are 47 cases listed. In C7, there are 63 cases listed. So which is correct? Who's going to check this? Next, please. Again, you will find both these candidates. On the left is JG Prince and on the right is another candidate. The reasons are the same. What we are highlighting here is that Congress and DMK, the reasons are same. So they don't even bother to use a little bit of imagination and give some cogent reasons. Next, please. And this is Bihar. Again, the same thing. You will find similarity in reason between different candidates of the same political parties, which is not possible. How can you give same reason for everybody? Next, please. Okay. Right. So now I'll invite the speakers, but I would just like to lay down a couple of ground rules. One is that we have given 10 to 12 minutes to each speaker, so kindly adhere to the time limit. And the sequence of speakers will be as follows. First, Professor Sastry, followed by Mr. Ray. Third will be Justice Lokur. Fourth will be Mr. O.P. Rawat, if he has joined by that time. And last will be Mr. Alok. At the end of the session, we'll have a question and answer session. And we will see, as per the time, how many questions we can take. Okay, now with this preamble, I would like to invite Professor Trilochan Sastry to set the ball rolling and give his opening remarks and set this context as to why ADR is doing this research and why are we highlighting this aspect. Over to Professor Sastry. Muted. Yeah. Okay, now we are here. We can hear you.
Yeah. Thank you. Once again, welcome to all the speakers and all the persons attending. There are a few issues on which ADR is actually seeking your guidance. So I think General Verma referred to some of them, but just for the sake of clarity, let me mention that. One is a long-standing issue of ADR that several Supreme Court judgments have been given. And this is one of the latest on criminality, where the court chose to ask for further transparency and reasons from the political parties. Now, usually these directions are either ignored or followed in a very casual manner. And we have been wrestling with this issue of what is the remedy for this. Now, in this particular case, the Election Commission has been charged by the Supreme Court to gather this information and monitor it. So the Election Commission has designed some formats, but the monitoring of this information and what happens in case this information is not complete, let us not even argue whether it is valid or not, but there are many missing items of information. Then what is the remedy other than going and asking for contempt of court? So we have many eminent speakers. So that is one issue that we would like to ask all of you. And we have some suggestions which maybe if the moderator permits, we may come back either towards the end, but we'd first like to hear from you. And the second is the issue of a basic fundamental question about the rise in criminality. I think all of us are aware that when we first got this data back in 2004, the percentage of elected members of parliament with a criminal record was around 20%, and it has been steadily growing, and now it is 43%. And actually the great leap forward was between 2014 and 19, when it went from about 34% to 43%. And of course, the ruling party, which has the maximum number of elected parliamentarians, is squarely the number one party with the maximum number of criminal candidates. I mean, there is no question about it. So when there is no intention whatsoever to abide by the Supreme Court judgment or by what anybody around the world would say, is that people with 50 cases, 40 cases, murder cases, rape cases, atrocities against women, they are not only given tickets, they win, and they are also inducted into the cabinet. General Verma has not highlighted, but even in the Union Cabinet, we have ministers with criminal cases. Now, why this is happening, we can go on debating, but the fact is that there is no intention whatsoever among the political parties to do this. And the Supreme Court's approach so far has been to ask for more and more checks and balances and more transparency. Now, the only way forward, perhaps, is to hold somebody accountable, not in a vague sense, a political party or some vague committee or something, but individuals have to be held accountable for not following the Supreme Court guidelines among with this tools that we have in place. And so, whether this can be legally done or not is one issue I would like to highlight. So let me stop here and let us see if time permits. There are a few things we may want to consider, which we will discuss at the end. But we are very eager to listen to all the other speakers. So thank you, General Verma, for giving me this opportunity.
Okay, thank you, Professor Sastry. We'll now request Mr. Ray to kindly give his views. I think he's muted.
Thank you, General Verma, and other honorable speakers in the panel. Can you hear me?
Yes, we can hear you now.
Now, all of us are aware of the Supreme Court judgment delivered in 2018 and 2020, and the follow-up actions taken by the Election Commission of India, and the responses given by political parties, particularly in the recently held assembly elections in 5 states, as rightly mentioned by Mr. Verma. Now it appears that the reasons for selecting candidates having criminal background that has been mentioned in the prescribed formats are not mostly tenable to ADR or, for that matter, any citizen of this country. Now, what could be the remedy towards it? My particular assessment on this is that the direction issued by the Supreme Court possibly very difficult to implement it political parties in all cases. There are cases where this can be implemented, but in most of the cases it cannot be implemented for various reasons. Because discovery it will take a lot of time. So to cut short, I can only give one suggestion that if election commission, because Mr. Verma said that it is not appearing in the website of election commission, something funny. Anyway, but election commission must be aware of the reasons given by the respective political parties regarding their candidates having political criminal background. If the election commission thinks that the reasons given by the political parties are not in consonance with the intent or purport of the direction issued by the Supreme Court, then the election commission should issue so-called notices to the political parties for an effective reply so that further action can be taken. Now the question is, what should be the further action? Further action is one can be there is the case of contempt of Supreme Court because the directions has not been properly adhered to. Secondly, Supreme Election Commission has enormous powers under the Constitution and the statute to take action is against the political parties. by suspending their registration. In India, possibly there is not a single case where this power has been exercised by the Election Commission of India. So the charity must begin at home all the time. The buck cannot be passed to the Supreme Court or ADR or other social activities because Election Commission is constitutionally responsible for holding election in a proper and effective manner and to weed out corruption as well as criminality which is being involved to the candidates of respective political parties. So primarily, it is the duty of the Election Commission entrusted by the Constitution. Now, if such actions are taken, I believe the many heads will roll down, and the political parties will also think twice and thrice to rectify whatever the default on their part or the lacuna in the direction issued by the Supreme Court can also come to light. Insofar as other reactions concerned, I think, I have seen, in some cases, it has been said the winning possibility, although Supreme Court did not accept that contention at all, rather mentioned in the direction that that cannot be a ground. Even though in some cases it has been mentioned that after giving so many reasons, he is the best candidate among all. Now, I would like to quote a few lines from one book written by Mr. Vaishnav. He says in his book that a criminal reputation actually helps at the hustings. Studying election results between 2004 and 2013, the author calculated that if the probability of winning an election is 7% for a candidate with an unblemished reputation, it increases to 19%, with at least one case against the candidate, and if the case is serious one, the probability of a win increases to 25%. So if the people accept the criminals as good candidates for their constituencies, to represent their constituencies, it is a very alarming situation, no doubt about it, and something should be done. More steps should be taken. Now, and it continues. He says, he continues that the more power should be granted to the Election Commission to Commission under the Constitution and the statute and the judgments of Supreme Court passed from time to time. Therefore, I think the main thing, the absence of will not only on the part of political party, absence of will on the part of the implementing agencies and especially the Election Commission of India. So many commissions set by the government in the past for electoral reform, neither the government adhered to those recommendations, never it was discussed in the parliament. I myself raised so many things for electoral reforms from time to time. Hardly there was anybody to listen to me, or even a single member submission not be sufficed. But the way ADR is working, some other social activists organizations, they are also working. And by and large, people are frustrated with the present political system, no doubt about it. We are definitely responsible for it. It does not necessarily mean that the others are performing their role positively and effectively. Thank you.
Thank you, Mr. Ray. I'll now request Honorable Justice Lokur to kindly share his views.
Okay, thank you. Thank you very much. I would like to begin by saying that, you've selected a very, very important topic for discussion and which can have very far-reaching consequences. Really, I think, we need to think about the issues that you have raised very seriously and find solutions. As of now, I think getting a solution is pretty difficult, but we will have to continue making that effort. I would like to, begin by assuming what Professor Shastry says is correct, namely that the political parties are not interested in doing anything about it. If criminals get elected, they get elected because they are supported by political parties. They are financed by political parties. So the political parties are not interested. If you go back, to the anti-defection law, for example, all right, the anti-defection law was passed, the 10th schedule to the constitution. But then over the years, you have realized that, even this is being misused or abused in a sense. For example, when a petition is filed before the speaker to disqualify somebody, the speaker says, "I'm not going to decide it. You do whatever you like." And we've had the Supreme Court, recently intervene and give a direction to the speaker that, listen, this matter is pending with you for the last 2 years. How about deciding it? He was given some time to decide it. The speaker said, "I'm not deciding it." Then one of the parties had to go to the Supreme Court, and the Supreme Court had to give a positive direction, and then it was complied with. Now, I'm not saying that the speaker was a dishonest man or any such thing. He may have been a perfectly fine gentleman, but there are these compulsions, political compulsions, which perhaps persuade those in power or those in authority to see how best to get out of the rigor of the law. And therefore, I think we have to proceed on the basis that the political parties are not going to cooperate at all. That leaves another institution, that is the Election Commission. Now, so far as the Election Commission is concerned, it has got vast powers. Way back in the case of Mahinder Singh Gill, the Supreme Court said very clearly that, listen, the Election Commission cannot just fold its hands and say that, listen, I have no power. What can I do? There's a gap. The Supreme Court said, if there's a gap, fill it. Article 324 of the Constitution gives you enough power to do whatever you like, as long as your actions go towards a free and fair election. So you have the Model Code of Conduct, you have various instructions that are being issued from time to time. All kinds of things are possible if the Election Commission actually applies its mind to it. And it can also use this power to say that, well, criminals, we will make sure that they do not stand for elections. How do you define a criminal? I'll come to that a little later. But criminals may not be, a proper word, but persons accused of a crime. Accused of a crime, we will make sure that they do not stand for elections. Now, the power is there. It is one thing to say that, the law doesn't permit you to make, some kind of a form which will result in a person being disqualified or being not eligible to stand for elections. Well, the law also doesn't prohibit you from doing that. So I think the first thing is the Election Commission should realize its powers under Article 324 of the Constitution. It should realize that free and fair elections is one of the basic structures of our Constitution, and use the power for free and fair elections. Look at this, recent decision of the Supreme Court, which said that this information has to be uploaded on the website and so on and so forth. Now, one of the duties that the Supreme Court has, or responsibilities that the Supreme Court has placed upon the Election Commission, is that if our directions are not complied with, if this information is not given on the website and so on, please bring it to our notice. All right, so that if necessary, we can take action for contempt of court. Has the Election Commission done that? I don't know, but my guess is the Election Commission has not done that. So if the Election Commission does not also, abide by directions that have been given, does not exercise its own powers, does not abide by directions that have been given by the Supreme Court, where do we stand? That is the problem. We've had this huge controversy about the assembly elections in West Bengal, 8 phases, going over a couple of months. That responsibility, has to be shouldered by the Election Commission. That yes, it is our mandate under the Constitution of India to ensure that free and fair elections are held, and we will make sure that free and fair elections are held. Now, those persons accused of criminals, how do you, get them out? One way, of course, is to, come out with a form which requires all details to be given. Now, we are aware of the fact that false cases are filed against people. So there has to be some cutoff point, and that cutoff point has to be an arbitrary cutoff point. The safest cutoff point would be when a charge sheet is filed and charges are framed. Now, unfortunately, this is where the judiciary comes in. Between the charge sheet being filed and charges being framed, sometimes it takes a couple of years. General Verma, you had mentioned about Akhil Gogoi. Akhil Gogoi, charges were filed against him, charge sheet was filed against him sometime in June last year. And till recently, I don't know if it has happened in the last 1 week or 15 days, charges have not been framed against him for 1 year. There are so many cases where charges have not been framed for many, many years. What do you do about that? Okay, so to say that, well, it's a heinous offense, it's a petty offense, this, that, and the other, well, yes, you can have a classification, certainly, for heinous offenses. But the role of the judiciary becomes important. That is the third stakeholder, so to speak, in this entire range of activities, apart from the political parties and the Election Commission. You have the judiciary. Now, you had in 2013, the Chief Information Commissioner say that, some information has to be provided if asked under the Right to Information Act by political parties because they are public authorities. That was in 2013, 7-8 years ago. The matter was taken up. It is pending in the Supreme Court from 2015 onwards. So the judiciary says that, what's the hurry? Things will take their own time. Okay, public authority ho ya na ho, kya farak padta hai? That it can't be like that. Then you have criminal cases that are pending for years together. Very recently, it came out during the lockdown. Pappu Yadav was accused of having, consistently violated the lockdown, and he was arrested. And it came out, of course, it must have been known, but it came out that he was accused of an offense of kidnapping or abduction, I'm not sure, way back in 1989, 32 years ago. The case is still pending. Right? In the meanwhile, he has got elected as an MLA, he's got elected as a member of parliament. What do you do? So the judiciary also has a great responsibility, and that great responsibility is in deciding cases expeditiously. It is one thing to say that special courts should be set up, that has been tried. Fast track courts should be set up, that has also been tried. Then special fast track courts have been set up, that has also been tried. And fast track special courts have also been set up. But the basic problem is that these cases have to be decided quickly. If a person has been falsely implicated in a case and he is told within a year or within 6 months or whatever it is, we will pass judgment, and if you're guilty, fine. You will know within a year. If you're not guilty, you will know within a year. It doesn't matter whether it's a petty offense, stealing a cell phone, whether it's a robbery or whether it's a murder or whether it's a rape. We'll decide it. And once that is done, the election law sets in, comes into motion. If a person has been convicted of murder, there's no way that anybody is going to, make sure that he stands for elections and gets elected. In any case, there's a disqualification under the RP Act. So really, the key players, that is the political parties, no action. Election Commission, yes, no, yes, no. Well, there's nothing more I would like to say. Judiciary, you have to be proactive. You can pass judgments like this, contempt of court, this, that, the other. But they have to be pragmatic. Now, you have shown, General Verma, about reasons. Now, all kinds of reasons can be given. What is a political party supposed to do? Call 100 people and say, listen, we are going to interview you, and then we are going to decide which one of you should stand for elections. It's impossible. So the directions are well-meaning. I'm not saying that directions should not have been given. The directions are well-meaning, but they are not capable of being implemented. Maybe there could be a time lag to involve people. That is the fourth category, which is of great interest in the free and fair election process. Fourth category is the people. They should have enough time to know through newspapers, TV, so on and so forth, social media, whatever, that this person, these are the allegations against him. If I want to verify and I'm given 24 hours to verify, I will not know. I will not be able to find out. If I know that a person has suppressed some candidate has, guilty of, accused of attempted murder, not disclosed, I know it. But if that information is not made available, what can I do about it? I can't do about it. I can't tell anybody that, listen, I know that there's a case pending against him. So the dissemination of information and the time lag during which a voter can make use of that information is also important. So to say that within 48 hours this has to be done, or within 36 hours this has to be done, the time may not be enough. Why not say that, all right, 1 month before the elections or 1.5 months before the elections, a nomination has to be filed, and let the people know for 1 month or 1.5 months, whatever, some period. So the people have to be involved. That dissemination of information must be there, and the dissemination, it's not that, okay, I put it in the newspapers. There have to be people who will say that, well, read the newspapers. I don't read newspapers. So how do I know? I don't watch TV. So how do I know? Right? So the manner of dissemination also has to be looked into so that the people get actively involved in this. So I would say that really, there are 4 stakeholders. I think each one of them has a duty, each one of them has a responsibility. One of them you can leave out, that is the political parties. And the other 3, of course, have an important role. One last point, the use of countermanding elections. I don't know when was the last time when an election was countermanded. I think we have to use that a little more liberally. The Election Commission will have to use that a little more liberally. It may come to know at some point of time that, listen, this guy has filed a false affidavit or something. Holding an election is expensive, I know, very expensive. But countermanding an election is like a surgery. And if a surgery is required, it has to be done. If you can't cure the cancer with chemotherapy, radiotherapy, you have to have surgery. Thank you.
Thank you, Justice Lokur. I'll now request Mr. O.P. Rawat to kindly give his view. Welcome, Mr. Rawat. Over to you. I think you are muted, sir.
Now it's audible?
Yeah, we can hear you now. Yes, sir.
Okay. So, Honorable Justice Lokur, General Verma, Mr. Ray, and other respected personalities present in this discussion. First of all, let me thank ADR and General Verma to have given me this opportunity to participate in this very important interaction. Secondly, I would just like to say that this whole proposition has two parts. First part is making voter take well-informed decision about the candidates, whether they are hardened criminals, whether they are accused of very serious offenses, and then decide whether to vote for them or not. I think that's fair enough, and that has really gone to the ground, as Justice Lokur has pointed out, that there should be effort to disseminate this information far and wide so that even an illiterate voter becomes knowledgeable about these things. Quite a few attempts have been made at different levels, and quite a few election authorities have ensured that even at the polling station, this kind of detail published in the newspapers is also displayed. So, helping the voter take a well-informed decision about the criminal allegations against their candidate is well taken. The second is really a messy area. Second part is extraneous people entering into the political process. Selection of candidates is core of political process, and re-entering into political process, even Honorable Supreme Court has stated in quite a few judgments that Election Commission has no locus standi to enter into political process per se. Therefore, when we try to enter the political process, we have to be very circumspect. Second thing here, entering into political process, the point Justice Lokur made that Election Commission can use 1977 ruling MS Gill versus Chief Election Commissioner and others to exercise its plenary powers to either countermand the election or to take action. I don't agree to that because Honorable Supreme Court has time and again said that this power is available only when there is a legal void, where there is no provision to meet a challenge before the commission. Now here, Representation of People Act, IPC, there are so many provisions to meet this challenge of criminality, and express provisions are made there. And Election Commission just cannot exercise that power under Article 324. And if at all we have to test waters, I think we can suggest to the Election Commission that in one particular case, let us try this, and when the matter goes up to the Supreme Court, let us see what happens. My personal view is that absolutely no, it is not available to the Election Commission. Now, lastly, I will only like to say that in case we are not succeeding this way, we must look for improving, expediting investigation and trials of all such cases. Justice Lokur also mentioned these things and expressed a little helplessness that how will it happen. But I personally feel that to bring faith of people in our systems, we must look into investigation system and the system of trials of such cases which are so important for formation of our parliament and government. I think that may help us get to a little better representative people through elections, and otherwise we will again be continuing to be at sea. Finally, I'll say that political conflict, earlier it is to be decided by killing people. Democratic elections have provided the most peaceful solution to the political conflict. And it is happening time and again in our country and even in other democracies, with some exceptions, that political conflict is decided most peacefully. Now, entering into political process by some proxies may not be in the best interest of this whole development. Thank you very much.
Thank you, Mr. Rawat. I'll now request Mr. Alok to kindly share his views.
Thank you. Thank you for inviting me to this event to speak about what I believe is perhaps one of the most important issues concerning future of democratic India, which is criminalization of politics. We are focusing on a narrow aspect of it. So let me address two issues right up before I go to what are the solutions. The first is we shouldn't try to drink the entire ocean in one gulp. Criminalization in politics has many, many different aspects. One aspect of it is, of course, the entry of persons of criminal background into the Lok Sabha and the Rajya Sabha and the various state assemblies. That is definitely one aspect of it, but that is not the only aspect of it, or not, or perhaps not even the worst aspect of it. Perhaps the worst aspect of it, and I will address again to use another metaphor, the elephant in the room, which is that there is a section of voter who doesn't mind or actively votes for a criminal when they're presented with a choice. I believe Mr. Ray perhaps mentioned this research right at the start, but I'll refer to it once again. It's this book which I have right here, When Crime Pays by Milan Vaishnav. He has used a lot of ADR data itself, and he has drawn a very depressing but true conclusion that a section of voters don't mind a candidate with a criminal antecedents. Obviously, that is a much longer frame. Changes are needed, but we have to accept that we can make smaller changes without necessarily being able to tackle the biggest change, which is this: that a certain section of voter doesn't mind a criminal candidate or even actively wants a criminal candidate. Right? That is as far as how we frame the problem is concerned. The second point that I want to make is that there is no concept of electoral reform without judicial and police reform. I think Justice Lokur and Mr. Rawat have before me have mentioned this. Let me just point out to say that we cannot just expect that even if political parties will it, right? Let's take the best possible case. Tomorrow, the Parliament of India passes exactly an amendment to the Representation of the People's Act, making the kind of changes that today we are discussing. I can tell you that without appropriate changes to the judicial system and our police system, it will not make a difference. We will still have the same problems of persons with criminal backgrounds getting into the picture. Now, having said these two very large points, right, I'm not saying that it's not possible to do any reform, but I do believe that, and I'll say this in like what can be done immediately, what can be done in the medium term, and what can be done in the longest possible term. All right, which will take the longest, I mean. The immediate change, and I believe, and I take a cue from what Justice Lokur has said, the directions issued by the Supreme Court in the two cases which we have been discussing so far, the trust for independent political science. What needs to happen is that those directions need to be reframed. I think two important things need to happen. One is that the Supreme Court needs to very specifically state out what are the reasons. It makes no sense to say that winnability cannot be a criterion. The Supreme Court needs to sort of just lay down specifically what kind of reasons are acceptable rather than just saying this reason is unacceptable, everything else is okay. And as Justice Lokur pointed out, that particular set of directions need to be reframed with an eye to making them more pragmatic. It should be something that political parties can comply with without a wink wink nudge nudge or doing such sort of copy paste as was shown in ADR's initial research itself. The second aspect of the change in the directions, this is the radical change that I'm suggesting, is that the Supreme Court should put enforcement in the hands of the High Court, by which I mean to say that the Supreme Court should say that at the state assembly election level, the compliance should be placed before the concerned High Court rather than the Supreme Court. We have to understand the Supreme Court, how many ever judges we may appoint, there is only one Supreme Court. Although judges have a limited amount of time, no matter how well intentioned, energetic, and efficient they are dealing with far more matters than they should be. And if we burden the Supreme Court to say, just to take an example, if we say the 5 state elections, now the Supreme Court should oversee contempt, I can guarantee you nothing is going to happen. What I would suggest is we have other high courts here who can help the Supreme Court in this respect. The procedural aspects can be worked out on this. I would say the Supreme Court should say, for the purposes of state assembly elections, we should look to place this before the high courts and let the election commission and the political parties file compliance compliance affidavits before the concerned high courts. This, I believe, will decentralize the process of enforcing these directions, enforcing the kinds of changes. That is at least a medium-term solution. It may not happen tomorrow. It may take a little bit of time for even the high courts to get an idea of what's going to happen. Finally, I have one long-term solution. And this long-term solution is something that is not very easy to achieve. It requires a different kind of political will, but this is a political will that has already been expressed. And this is in the form of, how do we change our political system such that that MLA or that MP is not the person who you put into power because he or she will serve the needs only of your caste. It's great that we are talking about what do you say, removing criminals in politics. But honestly, for someone sitting, I'm here sitting in Bangalore. My constituency is Bangalore Central. I may vote for the best person I think, however clean they are in the political situation. But for someone in rural Bihar, where whether the right person being an MLA or an MP is a literal matter of life and death. And I mean life and death in the sense of your enrollment in an Aadhaar might depend on it. Your enrollment in a government scheme might depend on it. Whether your children get into school might get into it. The kind of patronage politics that we are seeing, that is what has to change in the longer term. Unless that changes, unless we find a way to make the Indian state not be so centralized. And when I say centralized, I don't just mean central government. Even at the state level, we see enormous levels of centralization where somebody sitting in, say, a Bangalore determines what should be the vaccination strategy in Haveri at the other end of the state. So this decentralization, where the government that serves you is as close as possible with you, that you don't need a Bahubali to be able to go to the assembly and literally take favors for you on behalf of your caste or community or religion. That is what needs to be broken. And to that end, I do believe decentralization has enormous potential to just fundamentally change the way in which the Indian state works. As long as we believe people are passive recipients of what someone in a state or the central capital decides, the only way people are going to be able to approach these state and central capitals is through this kind of person who can show that I am strong enough to demand this from the chief minister or the prime minister. So I believe this is, of course, a huge long-term change. But I do believe if we take the term democratic reforms seriously, we have to include an element of decentralization into the context. And that also requires that there cannot just be one ADR. Let me just sort of end this on the point to say that we probably need 100 ADRs in this country. The task of ensuring accountability of elected representatives should not start and stop at the MP MLA level. It should go down to the panchayat and the corporator level. I do believe if we strengthen the grassroots of India's democracy, it will work its way up. If we change the way in which people hold their local government accountable, it will work its way up, and we will find that the people will weed out criminals on their own. That I think that is, I think Justice Lokur also made this point. The biggest ally in this will eventually be the Indian electorate. And more than any institution, we can strengthen the EC all we want. We can make the judiciary as independent as we want. We can make the police as efficient and effective as we want. But the only real way to drive democratic reforms in this country is to make the electorate an ally. And the electorate will be an ally when you show them that the reforms that we're asking for will fundamentally change how governance works, and not just in terms of we will reduce number of criminals and MPs and criminals in Rajya Sabha, Lok Sabha by X percentage. That's all I really wanted to say. Thank you once again for this opportunity. It's been a pleasure listening to my co-panelists as well.
Hello, can you hear me? Okay. Thank you, Mr. Alok. Now we'll start with the question answer session. Some people have already emailed their questions to us, and there are some addressed to Justice Lokur and some to Mr. Rawat, but he just messaged me that he had to leave. There is some emergency. So we will take the questions on one by one. While they are putting out the questions on the ticker tape, Professor Sastry, would you like to say something before we start the question answer session? You're muted.
Later on by all the other speakers.
Okay.
Yeah.
Okay, let's please put out the questions. Okay, first question is why EC must not be held guilty for not initiating criminal cases against election candidates, conduct election rallies by violating pandemic rules such as social distancing, mask supply, sanitizer. If not, what stops EC from initiating appropriate legal action against candidates now? Anil Singh, CEO, TV5 Kannada. Now, Mr. Rawat has left. So we had actually invited somebody from the Election Commission of India, but they did not respond. So I was hoping that Mr. Rawat would be able to answer this. But as Justice Lokur mentioned, this elections which were held in these 4 states and union territory in the midst of the pandemic, and the rules were flouted. I mean, issuing guidelines by the Election Commission is one thing, but implementing them on the ground, and then the fight between the state as to is the state responsibility, law and order is with them. Others say the Election Commission is in charge of the state when the elections are being held, so it is their job to implement it. But unfortunately, nobody did. So elections are over, results are out, governments have been formed. A lot of people suffered due to the COVID. A lot of people died, but there is no accountability. That is the status. So that is probably what the questioner is asking. Does somebody have to? May I request Mr. Ray to kindly speak on this? Kindly
Because
unmute.
in February of this, is my mic on?
Yeah, we can hear you. We can hear you.
Is it all right?
Yes, we can hear you.
Okay. Now, this is a very valid question. First of all, it also crept in our mind when the Election Commission declared that particularly in West Bengal, the election be held in 8 phases. We were wondering how the COVID situation could be tackled. Because since February this year, the second wave of COVID started all over the country. So initially it was very slow spread of COVID virus, but ultimately the pandemic created havoc. But the reply from Election Commission was that to ensure free and fair elections, they had no other option but to hold the election in 8 phases. And they assured that the elections will be free and fair, although several lives were lost due to clashes during election when the Election Commission took control of the situation. But forget about the political clashes and the death that occurred for the time being, because we are discussing another aspect of the question. It is really shocking that people were not getting oxygen. And for want of oxygen, hundreds of people died. And when it was happening, the Prime Minister was almost a daily visitor towards Bengal. He was addressing rallies after rallies and saying that I am so happy that I have never seen such a huge gathering in my meeting in my life at all. So indirectly, he was also encouraging more turnout in the political rally and meeting. This is absolutely unfortunate on the part of the Prime Minister of the country. If Prime Minister shows the path, what else can be expected from others? So this is my notation.
Okay, thank you. Can we have the next question? Candidates with criminal case pending cases beyond 1 or 2 years must be identified in red color on the EVM. The purpose of disclosure will be served when a candidate at the time of voting has the information. It is practically not possible under any circumstance to read newspaper or watch TV or EC website and remember or make a note of disclosure then vote. This is similar to a disclosure caution while making investment in any assets for making informed. Kindly say method to implement the same. Well, this is a more of a suggestion given by TV5 Kannada. This is for the election commission to ponder over whether it can be done. As it is, there are a lot of issues about the EVMs.
Just one fact, I think, for the viewers. The State Election Commission of Maharashtra for the local elections has actually implemented this, at least in principle, in many places where they're actually putting up the criminal cases at the polling booths. I think the Election Commission should also seriously consider this. I know it's a very sensitive subject, but drastic diseases, cancer in the society requires drastic measures, and they should be put up on the polling booths at the time of voting. People can see it. It's a good suggestion. We can't always hide behind administrative conveniences and difficulties in implementation and all sorts of things we've been doing for so long. They should be immediately done.
Yeah, if I may add, the Madhya Pradesh SEC had also implemented this.
So, what prevents the Central Election Commission?
Yeah. Okay, can we have the next question, please? Why the rules are not being passed in Parliament, Mr. T.D. Pathak? May I request Justice Lokur to speak on this, because in the last Supreme Court judgment it was mentioned that it's not the role of Supreme Court, it's the job of the Parliament to legislate on such matters.
Yeah, I think if I heard you correctly, the question is why are these rules not being passed in Parliament?
Yes.
It's a question which is impossible to answer. I mean, there are so many things that can be done, but a Parliament has to debate and discuss all this. Let me give you two examples. All right, you have the issue of sexual harassment of women at the workplace. Now, India had signed the International Convention. All right, not implemented. I mean, it signed, ratified, everything done, but not implemented. Supreme Court in the Vishaka case in 1997-98 or 98-99, they said that you can't have sexual harassment of women in the workplace. When did the law come? It came in 2013, after 15 years. Right now, how about asking Parliament that what took you 15 years to enact this law? What answer are you going to get? So, really, why Parliament passes a law, why it does not pass a law, why it delays the passage of a law and, issues ordinances and so on, is really for Parliament to answer.
Right.
None of us, I think, can answer that question.
Okay. Thank you, sir. Okay, can we have the next question? Nominations are getting filed just 10 to 12 days before election date. 72-hour means loss of 3 days. Are 7 days sufficient time for people to shortlist the candidate? Can this be increased to 30 days? Mr. Suresh. Can I request Mr. Ray to throw some light on this? Nominations are getting filed just 10 to 12 days before election date. 72 hours means loss of 3 days. Are 7 days sufficient time for people to shortlist candidates? Can this be increased to 30 days?
Unless there is consensus on the part of political parties, it is not possible to implement. One party may think so, but if the others do not agree, then it will be difficult on the part of the election commission to arrive at a consensus.
Okay, thank you. Can we have the next question, please? Please do interpretation of Article 282. What was the original intent when 282 was approved by the Constituent Assembly? Concern is that union government has been spending too much on subjects neither in, next please. Union government spending too much on subjects neither in union nor in concurrent. Big example is Panchayati Raj entirely a state. This is causing centralization and undue vote bank influence to party in power. Suresh. Question to Justice Lokur.
Yeah,
Actually,
I'm not clear. Yeah,
actually, this is not really relating to the subject, but
yeah,
he is
yeah.
addressed it to you, sir.
I've not been able to understand the
So what
question.
he's saying is that the Article 282 is being misused by the central government by allocating funds randomly.
Uh-huh. Yeah, well, I don't know what to say. You know, we have to. I mean, so far as elections are concerned, candidates are concerned, and so on. I think we need to, get right down to the basics. Panchayati Raj institutions are important. There's no doubt about it. But so is Parliament, right? So if more money is being spent on Parliament, less on Panchayati Raj elections, I think that is something which the government or the state has to decide. But one thing I think this Article 282, actually is about expenditure being defrayed by the state or by the union out of its own revenue. That is a possibility. I think that has also been discussed whether the elections should be funded by the state or should be funded by political parties. I don't know. I frankly I don't have a view on this, but you have things like the bearer electoral bonds, right? So you have so many people who want political parties to fund the elections. So I don't know. This is something which is definitely worth debating and should be debated. Whether the state should fund the elections or whether political parties should fund the elections, and how do we limit the expenditure? It is very, very important, and it's a part of the entire package of electoral reforms.
Yes. Thank you, sir. Okay, next question, please. Do we have any other questions? What is the remedy open for non-compliance by the political parties and the Election Commission of the detailed categorically directions of the Honorable Supreme Court in para 4 of the order, dated 13/2/20 in contempt petition S.N. Shukla, General Secretary, Lok Prahari. Question to Honorable Justice Lokur.
Yeah. Well, the only power that the Supreme Court has got is that of contempt, right? Nothing else. And I don't know, whether the Supreme Court will use that power in the case of the Election Commission. violating the orders of the Supreme Court. I had mentioned that reports have to be given by the Election Commission to the Supreme Court. Election Commission doesn't seem to have given that report. Is the Supreme Court going to issue notice of contempt to the Election Commission? I don't think so. That's why I had said that these directions will have to be pragmatic. They have to be directions which can be enforced, which can be complied with, and then enforced if they're not complied with. You can't say that I'm going to put the Chief Election Commissioner behind bars, and then like it did like it happened in the case of Prashant Bhushan, 1 rupee. Election Commission also, all right, yeah, you take 1 rupee. That's the end of it. So we have to be, practical, pragmatic, realistic before we give these kind of guidelines.
Thank you, sir. Okay, next question. ECI is competent in all election matters, so the same information must be available on the ECI website. Many false information may be submitted by party candidates, so which type of verification? Next. The process is maintained by ECI, Mr. Sahu. The question itself is not very clear. What is he asking?
Let me respond to this. This is an old issue ADR faced right from day one, 2002 or 3. But what should be done in the case of false information? So the Supreme Court directive and the Election Commission's own concurrence on this directive is that it will not verify the accuracy of this information, partly because the Election Commission does not have this information with it. All the information on all the candidates in the country, new candidates, what are his assets, what is his criminal record, they cannot verify in the short term available. So they would just take it on record. However, legally there is a provision that if there is false information that materially affects the outcome of the election, it can be challenged in a petition. And in a few odd cases, I think 3 or 4 that we are aware of, such elections have been in fact set aside. So that's where we are. That's why the Election Commission does not have a database of the entire country on all the criminal cases and assets and financial records and educational qualifications of every candidate. So that's why it's not being done.
I suppose sometimes there is also a provision that a petition can be filed by somebody who feels aggrieved that wrong information has been submitted by a particular candidate. So it has been done a few times, generally by the losers. Okay, next question. The EC is required to arrange by-elections at huge public expense due to resignation of MLA MP during his or her tenure. The expenses so incurred may be realized from the person resigned. Shyamal Chandra Das. Well, this is more of a suggestion, and we've seen this recently in the case of West Bengal, where people contested who were earlier MPs. Now they have resigned because they wanted to make way for somebody else. So this is a new thing which has started, and I agree with the question that it's a waste of money. But how to recover it and all that, I don't know. So some views somebody can give. Mr. Ray, would you like to say something?
In fact, the case that you have referred, 3 sitting MP of Lok Sabha, they contested the assembly election, and all of them were elected. But ultimately they decided, because they have to choose the 2, whether they will retain the assembly or the parliament seat. So they retained the parliament seat and left the assembly seat, as a result of which there will be by-election again. This has happened in cases of 2 MPs of Lok Sabha of the
But the questioner is asking somebody should bear the cost. That is what he's asking.
Yeah. Yes, yes. It's very justified. Very justified.
Thank you. Any other question? I think we can have one or two questions and then call it off. Mr. Narendra, CH. Our publication of criminal cases and affidavits by candidates is having an impact on voters. Our publication of criminal cases or giving reasons for selecting such candidates influencing the outcome. I think this is directed at ADR. So I'll request Professor Sastry to say something on this.
Yeah, I think all of us in ADR have been aware for several years now, maybe more than 10 years. And the book by Professor Milan Vaishnav, which was referred to by two of the earlier speakers. Actually, there are three issues here. One is that this information is actually not completely known to all the voters. Number two, for example, Justice Lokur referred to Papu Yadav and many other stalwarts. The people in the local area know about these candidates. They know what kind of a person he is and that he had gone to jail for murder. All these things are well known. There are people with 50, 60 cases, 30 of them murder cases. The voters in that constituency know about it, but still they vote for them. So our feeling is that there are other factors which outweigh this issue of criminality. We can discuss this for a long, long time. So there are only 2-3 remedies because that begs the question that what should be done. One is, of course, all the things that we have discussed in this webinar on how to prevent such people from standing. And the other is more and more voter education, which the last speaker, Prasanna from Vidhi, also talked, that the voters have to start thinking differently, and that thing about raising the awareness of voters is a national task. It's not just a simple thing. It's about changing the consciousness of people. So that task has to be done. So till then, we will have to live with this remedy and hope for structural and supply side situation. The law, the election commission, the Supreme Court, somebody or the other will take action. But we hope that they will, but ultimately the people will have to take action and reject such candidates. And in fact, that's why ADR has a strong youth program, and we are trying to expand it as much as possible so that more and more people think about these issues and worry about whom are they electing and so on and so forth. So let me stop here. Yeah.
Thank you. Nandini, one last question, please. Pawan Saini, if a government employee loses its job or suspension if held with any criminal case, why the politicians not getting same treatment?
That is the ADR question, General Verma. We have been saying that if you have a criminal case, you cannot get a job as a class 4 peon in a government job. The funny thing is, if you are putting suspended after you are confirmed, no amount of wrongdoing will ever make you lose your job. But to get in is very difficult, and we don't have the same barriers for the politicians. So this has to be there. There are all kinds of subtle, legal, technical arguments, the right to represent people, the right to stand for elections, and so many arguments are there which we have gone through the last 20 years. But we are not able to take a position either in the Supreme Court or in the election. It was very interesting to see the Election Commission and the Supreme Court passing the ball between themselves. Justice Lokur saying that the EC can easily bar criminals in spite of all the Supreme Court judgments, and the EC saying no, we cannot do that, and the former Chief Election Commissioner saying we cannot do that, and all of them are giving very sound, logical reasons, but the country continues to suffer. We need to have either a Chief Justice or a judge in the Supreme Court or an election commissioner who has the guts and the boldness and the patriotism, who loves this country and the people, to take that decision. Not to say unko karna chahiye, unko karna chahiye. We are still in that phase where the stalwarts in these constitutional bodies are saying unko karne do, unko karne do. खुद क्या नहीं करते हैं? Let me stop there.
If I can just add one last point
Yeah,
on that.
Mr. Alok. Yeah, please, Mr.
No,
Alok.
I believe Justice Lokur had asked this question, and I forgot to mention while I was speaking. Actually, the last time an election was countermanded was in 2019 in Vellore constituency, when the then district election officer, cancelled the election in that area, saying the influence of money is too much. Now,
Yeah.
it did cause a bit of controversy, but I believe he was fully justified in doing so because of the amount of cash. I mean, you can ask anyone in Vellore about it. They will say, yes, of course, he did the right thing, because the amount of money power that was being used to influence an election was simply unacceptable. So there is that power. It takes, and as Mr. Trilochan Sastry mentioned, it takes one particular officer of that particular bent to say, this is just unacceptable. Everybody in this list is red in terms of their criminality. I'm going to countermand the election. I will fight it in court. And I'm 100% sure that judiciary will probably back that person. So, which is why it's possible. We just need one person to take that call.
If I remember correctly, Alok, when the election was held again, it was the same candidates who contested.
Unfortunately. Yes,
So,
that's unfortunate.
and they won also, whoever was. Anyway. So I think we'll end the question answer session here, because we're now close to 1.5 hours. And before we wind up, I would request all the speakers to kindly give their closing remarks, brief closing remarks, and request Justice Lokur to kindly start.
Yeah, thank you. Well, just by way of closing remark, I would say that ADR is doing a wonderful job. Please continue it. Right? We need to get people more and more involved. I remember asking in one university program, that sort of a webinar, that how many of you know who is your local MLA? Many of them were, from outstation. They were staying in the hostel. I said, you find out, just ask yourself, do you know your local MLA in your place of residence, in your hometown, or in the place where your hostel is located? Later on, I was told by the organizers that only 2 or 3 of the students were able to say who was their local MLA. So the people have to get involved, and it's good that, we are talking about it, but unless we get involved in this also, these discussions will continue for the next 10 or 20 years. So we have to get everybody involved in this. Thank you.
Mr. Ray to kindly give his remarks.
Thank you. One second. I am just sharing one of my personal views. I am also carrying a stigma of having a criminal background. Against me, a criminal contempt case was instituted as long back as in 2010, and for the past 11 years, that case has not been resolved. And every time I have to file in my affidavit that yes, a criminal case is pending against me, and under section 500 of PC, etc. Now, I have seen at least 2 of my colleagues, one in the upper house, another in the lower house. They have amassed huge amount of money from their bank, but they have not been termed as willful defaulters. And even if they have termed as willful defaulters, no criminal action has been taken against them. Rather, resolution process is going on for years together, And now, with the help of this bankruptcy and insolvency court, God knows how and when they will resolve everything. So they are not criminals, but only a person who has filed a criminal contempt against me because I made certain remarks in the television, although I personally strongly feel that for which no criminal contempt arises at all. But even though it is sub judice, I must not say anything. But it is sub judice for long 11. So there must be some distinction between, as rightly pointed out by so many speakers, particularly by Honorable Justice Lokur, that the heinous crimes like sexual abuse, dacoity, murder, etc., and cases like one that I am facing for the past 11 years. These two should be distinguished. That is my suggestion to the ADR, which is doing a very great job to the society for a long time. And personally, although this is my first chance to participate in the discussion, but I have enjoyed the discussion. And I extend my regards to all the panelists, and I wish all success for the ADR. I have seen one appeal from ADR to donate so that they can continue with their activities effectively. I am sorry to say that I am a 72-year-old person. I have never used card in my life. So if there is other mode of payment, I can also contribute some money to your organization.
Thank you, sir. Thank you. I was just seeing a message from Mr. Naseem Zaidi, the former Chief Election Commissioner. He said that in 2016, RK Nagar constituency was also countermanded, and it was again countermanded in 2017 on money abuse. So it is possible to set examples, judiciary supported for free and fair elections all through. And there is one for Justice Lokur from Professor Jagdeep Chokar, who is also our trustee. How would Justice Lokur react to a possible response to the question about why Parliament is not passing the required laws? Because the Parliament does not appropriate people. Uh, I think Justice Lokur is muted. Can you please unmute him? No, it's again muted, sir. Yes.
All right. Yeah.
Yeah.
With regard to Parliament not passing laws, I think Mr. Ray, who is a member of Parliament, is probably the best person who can answer this question. There's nothing I can say about why Parliament should not, why Parliament is not passing a law. I
Okay.
think, yeah, Mr. Ray.
Ray, would
perhaps
you
you can-
like to say something?
Yeah. Only one line answer. I am representing All India Trinamool Congress in Parliament, but I am not representing Indian Parliament in this discussion.
Okay. Thank you. I'll now request Alok to kindly give his closing remarks briefly.
Thank you, Major General Verma, for inviting me to this. It's been very educational and very important for me. It's been a great learning experience listening to all the panelists also. But if I have to offer a closing thought, it is that I think this is a long-term project. I think we shouldn't see the idea of the democratic reforms cannot just be that we look to implement court orders or get a good order from court. Those all help. Those are all small steps. But I think the larger goal of deepening India's democracy requires us to take much more long term reforms. I've mentioned about three of them being judicial reform, reform of the police, and also strengthening India's grassroots governance. And I think that kind of reform will help push forward the larger agenda of ensuring that politics serves the people in the country. And with that hope, I would always say that ADR has been doing excellent work. I only hope it widens and deepens its work into these areas also, in a bid to like further India's democratic revolution. Thank you.
Thank you, Alok. We have limited resources and capabilities, but we'll try. In the end, last Professor Sastry to give his closing remarks and certain recommendations which you mentioned at the beginning that you would like to speak about them at the end. Can you just unmute it, please?
Sorry.
Yes.
So
Yeah.
while I will stick my neck out and give some recommendations, whether they are feasible and all and implementable, we'll discuss it later among ourselves within ADR. First is, yes, it is a very technical thing, and technical details about courts and criminals are not going to solve the problem of democracy. We agree with that. So we have a whole agenda beyond that. But I'm sticking to the point of today's discussion, which is framed about the Supreme Court contempt of court, sort of not following the Supreme Court directions. We should ask the Supreme Court to clarify its judgment and specifically say who are the one or two individuals who will be held responsible for contempt of court in case these directions are not followed. And by the way, here is our homework which shows that in hundreds of cases it has not been followed. I think the party office bearers have to be held accountable, and for contempt of court, I think they go to jail for a few days, whatever the thing is, that should be done. So until there is personal accountability, generally talking about the system, because they are the people who are giving tickets. So let me sort of get that out of the way. But in terms of closing remarks, I think we agree with all the suggestions, and particularly with what Prasanna said just now, that there is a very big agenda and we are doing our bit, but ADR cannot do everything. And I would like to close by thanking the 46 viewers who were there at 3:54, which came down to 45 by 4:12. Thank you all the people who have patiently listened to and participated. And thanks very much for all the people who asked questions. Please continue to engage with us, and we will help you and you will help us to take our agenda forward for this country. And we are trying to figure out how to involve more and more people. And there is a big gap in what we do. We do these discussions among people who speak English, who largely do not vote, and people who understanding of politics is completely different from the understanding of politics of the grassroots people. Completely different. Because I have the misfortune of working with about 40,000 farmers in the villages. Their way of thinking about it is completely different from what this august, highly educated, English-speaking urban group thinks about politics. So we have to figure out a way of involving them as well in this process. So my last remark is thanks a lot for all the viewers who came and all the questioners who asked questions.
Thank you, Professor Sastry. So, in the end, from my side, I would like to thank all the esteemed panelists who took their time out and gave their views, which we'll try and formulate into a paper now and submit it to the Election Commission in a few days. And thank you to all the viewers who participated and gave questions, and I hope that they were answered from our side. Thank you very much. All the best.
Okay.
Thank you.
Thank you. Thank you.